Tonight, President John Mahama removes Chief Justice Gertrude Arabasaki Torkonoo from office with immediate effect on grounds of stated misbehavior following the submission of a damning report by Justice Scott Puaman Committee. We'll hear from Government Communications Minister, who has dispelled views that President Mahama's historic decision is a political witch hunt.
And they recommended the removal of the Chief Justice for stated misbehavior. The former Deputy Attorney General is fully aware that the President has no choice in the matter. The President cannot decide to agree or disagree with the findings of the...
Meanwhile, former Deputy Attorney General Alfred Tuah-Yeboah has described the removal as a huge assault on Ghana's judiciary.
But from what we read from the petition, if this can form the base for the removal of a Chief Justice, I give up. I'm sad but not surprised.
We'll bring you more reaction from the legal community here on Top Story. Top Story, as always, is brought to you by Telecel Connecting Energies. My name is Faustina Safo. Please stay for details. Thanks for choosing us. Tonight, President John Dramani Mahama, in a historic move in Ghana's judicial history, has removed the Chief Justice Gertrude Arabasaki Torkonoo from office with immediate effect. Well, this follows the submission of a damning report by the Justice Scott Puaman Committee. The committee, established to investigate petitions against the Chief Justice, found grounds of, quote, stated misbehavior, unquote, and recommended her removal. The removal of the Chief Justice, Gertrude Torkonoo, marks a significant milestone in the country's judicial history, as she becomes the first sitting Chief Justice in the Fourth Republic to be removed through a constitutional impeachment process. President Mahama acted swiftly, endorsing the committee's findings and effecting the removal in accordance with Article 1469 of the 1992 Constitution. After sifting through 10,000 pages of evidence, the committee concluded that the Chief Justice had indeed engaged in misconduct, warranting her removal from office. Now, despite her vigilant efforts to resist the probe, including filing suits at the High Court and the Supreme Court, and even seeking recourse at ECOWAS courts, the committee's findings were deemed conclusive. Justice Puaman submitted that report to the presidency today. Here's what he said.
Mr. President, in March this year, you received 3 petitions pursuant to Article 146 of the Constitution 1992 for the removal of Chief Justice Gertrude Arabasaki Torkonoo, and the public was made aware of these facts. Subsequent processes dictated by the Constitution and the decisions of our Supreme Court were gone through, culminating in the establishment of our committee under Article 146, Clause 6 of the Constitution. The nation was further duly informed, and when we commenced our work on the 15th of May 2025, the Minister of State for Government Communications was briefed to notify the public about it. There has been considerable interest in our work, shown through comments and opinions by Ghanaians and international observers as well. However, the committee restrained itself all along from reacting, even when blatant false statements were made about members of the committee and our work. To the committee, our mandate and remit is set out under Article 146, Clauses 7 and 8 of the Constitution. It's clear, and it is to inquire into the petitions in camera. Here, the person against whom the petitions have been brought in her defense by herself or by her lawyer or other aspect of her case, and then make a recommendation to you, Mr. President. As I have said above, 3 petitions were referred to us. And though all 3 petitions seek the same relief, each petition is distinct and would succeed or fail on its individual strengths or weaknesses. Mr. President, without disclosing the substance of the proceedings, and since in-camera proceedings is not the same as in secret, we can state that in respect of the first petition, we received evidence by Mr. Daniel Ofori, the first petitioner, through 13 witnesses. Similarly, the Chief Justice in her defense called 12 witnesses, including expert witnesses, as she is entitled to do under the Constitution. The Chief Justice testified personally and was cross-examined. The committee received about 10,000 pages of documentary evidence from both sides. There were 4 lawyers that represented the first petitioner, Daniel Ofori, and 4 lawyers represented the Chief Justice. Mr. President, after critical and dispassionate examination and assessment of all the evidence, including the expert evidence, against the provisions of the Constitution and the relevant laws, we have, without fear or favor, arrived at a recommendation on the first petition. The recommendation is contained in the envelope which I now give to you.
Well, the President has acted on the committee's recommendation and removed the Chief Justice from office. My colleague Michael Ashale joins me in the studio. Michael, now you've been following this story, especially the first time when the Chief Justice broke her silence on this, when she accused the presidency of breaching due process. But let's start currently with the presidency's statement confirming that indeed she has been removed from office.
Well, so that statement from President John Dramani Mahama is just a one-page statement and goes ahead and says that, well, this is in accordance with Article 146, Clause 9 of the 1992 Constitution. President Mahama has removed Chief Justice, Her Ladyship, Justice Gertrude Iraba Isaba Saki Torkonoo, from office with immediate effect. It tells us that this follows the receipt of the report from the Justice Permanent Committee that they received earlier today, and that in accordance to Article 146, Clause 6, to inquire into a petition submitted by the Ghanaian citizen, Mr. Daniel Ofori. Now, after considering the petition and the evidence, the committee found that the grounds of stated misbehavior under Article 146, Clause 1 had been established and recommended her removal from office. So, the major reason that the presidency is giving us, or telling us the committee recommended to them, is that the prima facie case, as alluded to by the Council of State at the time that they written to President Mahama, has not been confirmed, and that the reason they can find that and put that under is stated misbehavior by Chief Justice Gertrude Torkonoo. And this, he says that, well, in accordance with Article 146 Clause 1 and 146 Clause 9, they have recommended, President John Dramani Mahama, has assented to the recommendation from the committee and removed her from office.
Interesting times ahead. But so far, the removal of the Chief Justice has sent shockwaves through Ghana's legal and political circles. The legal community, they've been reacting to this. They say it comes to them as no surprise. Let's listen to the former director of the Ghana School of Law, Ansa-Asare, speaking on this issue on the Pulse on the JoyNews channel. He says, so far, there is no evidence that the president is breaking the law.
I expected this, outcome. But the verdict is in accordance with the recommendation of the CJ removal committee. And once the committee recommends the removal of the Chief Justice, the president has no choice but to perform his constitutional obligation to remove the Chief Justice. The Chief Justice did not, give herself any chance whatsoever, to be heard appropriately. I mean, the confrontational, attitude that she took, made it impossible for her to return, to resume her official duties. She was so abrasive, taking, the government here, government there, going to ECOWAS, and I don't think, that we should be sad about this. We should rather be happy.
Happy for what? Exactly.
Yes, that the constitution is working. This is a democracy. And if the president has to act, every step the president takes, he must act in accordance with the constitution. So far, I am yet to be convinced that the president has contravened the constitutional processes. No one has been able to pinpoint exactly where President Mahama has gotten it wrong.
Well, human rights lawyer and lecturer at the University of Ghana School of Law, Professor Appiagyei-Atuah, agrees that no law has been broken.
Constitutional angle, the process went as laid down in the Constitution, and you cannot talk about any constitutional steps which were sidestepped or were not followed. But when you look at the political angle, it may tell a different picture. And I think that is where Mr. Tuah-Yeboah may be coming from. And it's difficult to read into that and to read the mind of the president and conclude this way or that way. But I think that with all due respects and looking at the matter from the angle of the Chief Justice's steps, making applications here and there, motions here and there, I think it was her right to follow those procedures. So in my opinion, I don't think it's any, her posture may have contributed to her removal. She had to fight for her rights. And it's difficult to read into the political motives, but constitutionally, nothing wrong was done. And I agree with the decision that was taken by the president. So long as the decision has been made by the committee, there's no need to wait for even a second or two, because the decision has been made. And it is also, he is bound by the Constitution. The Constitution says he shall abide by the decision of the committee. So that is exactly what he has done. I've already made a point that there are some constitutional loopholes, and probably this was taken advantage of by the president, or he relied on it to ensure the removal of the president.
Well, Michael Ashali is still with me in the studio as we look at some of the key details of these petitions. We know that there were 3 different petitions brought before the committee, and so far they have finalized on just one. Give me details of this petition by Daniel Ofori.
So, as far back as 14th of February, that's when the first petition against the Chief Justice, Torkonoo, was sent to the presidency, and this was from Shining Stars, Ghana. And that the allegation was that incompetence and breach of constitutional process. Again, sometime later after that, then we know that Yakubu Akogo also sent one. That allegation was that gross misconduct during a court proceedings. The person went ahead to talk about the Chief Justice that was sitting on the case at the time had given some orders for that person to be removed from the court. We've had the Chief Justice respond to that wasn't the account of how it happened actually, that the person was disturbing the procedure of the court. Now, sometime later after that particular second petition, that's when the third one comes. The third one that is sort of the final nail in her coffin, Daniel Ofori. And this allegation was that generally misuse of funds for personal travel and expenses. And firstly, definitely, the details we know, as he wrote in that petition to the presidency, this was specifically sent to the president on the 17th of March, 2025. Now, it says that it was accusing the CJ of misappropriating over 261,000 Ghana cedis in public funds in 2023 for personal international trips with her husband, Mr. Francis Kofi Torkonoo, and daughter, Edem Torkonoo. Now, as part of the allegations, he also alleged that she also collected over 75,580 Ghana cedis for a separate trip to Tanzania and failed to properly account for a $14,000 interest. And these are the major allegations that he sort of raised in his petition against the CJ, for which he felt she should be removed. Don't forget again that the Council of State had sat on these petitions and had given the president the go-ahead to forward it to the Justice Performance Committee for it to be probed further.
Well, let's listen now to the Deputy Attorney General, Alfred Tuah-Yeboah, reacting to the petition.
I'll say I'm sad but not surprised. I'm sad because this is an an unholy assault on the independence of the judiciary. This has a far-reaching consequence moving into the future. This goes to buttress the point that whoever sits in as a Chief Justice from today should also be thinking about the future implications.
Even if there is no case of stated misbehavior against that person?
I'll be coming there. If you sit in that office, the possibility of flimsy petitions being used to remove you is very high. That's what I'm talking about. And I'm not surprised because this one is in fulfillment of a campaign promise. This is a clear case where a political actor before elections campaigned on the promise to remove a Chief Justice. Upon assuming office, had some people filing petitions for the removal, and today the result. Looking at the current petition that has been used to remove the Chief Justice, I can say without any fear of contradiction that anyone who sits in that office as a Chief Justice will have the possibility of being removed based on text flimsy petition. That is my fear as a lawyer.
And that will mean virtually destroying this independent arm of government.
I tell you, that's what I'm saying. We've broke that virginity, we've destroyed the judiciary, and posterity will not forgive us. The removal of a Chief Justice is a serious business, but from what we read from the petitions, if this can form the base for the removal of a Chief Justice, I give up the threshold. If the threshold is so low, as we've seen in this case, then it will be so easy for any Chief Justice to be removed. I agree that we won't due for, even though she had challenge with regarding her fundamental human rights.
Former Deputy Attorney General there, Alfred Tuah-Yeboah, warning that the removal of the Chief Justice actually sets a dangerous precedent and chips away at the independence of the judiciary. Let's explore this further here on Top Story. Join me now is Ni-Aikwe-Otu, his lead counsel for the Chief Justice. We appreciate your time here on Top Story. I want to start with your initial reaction. I'm sure you've been engaging your client. What's her demeanor as we speak?
Well, let's talk about what has happened now. Not a demeanor. The important thing is that let me say I do associate myself completely with all the sentiments expressed by my colleague Tuah-Yeboah. That is a very dangerous precedent that they are setting, and it will come back to eat them. It was clearly stated that they would make sure that she is removed. This is not only against the Chief Justice, but we are hearing about sentiments of removing the chairperson of the UC and all the other top members of the UC. That has also been counted. So it's a very simple matter, as Tuah-Yeboah put it. Just call one or two people to present some sort of petition, and then immediately you say, "Oh, I've made a sort of factual determination," and then the people will set the processes on, and then, like it has happened this morning, we are told that she has been removed. First of all, we are those admin the petition, but because of the in-camera hearing, we refuse to engage the media. But now that it's over, I think we have to talk. 3 petitions were filed. They dealt with one. They adjourned the others, especially the one involving the Charlotte Star, to 15th of September. That day has not arrived. Now, at the end of every trial, now that we have so many people reading law, I think everybody knows that at the end of each trial, you are entitled to file a written address tell the court or the committee how you saw whatever it was. We were asked to file our written address last Monday. We asked for 1 week extension. They told us we could try and do it within the time. We only filed it today. Before we could say that, they have report presented and petition already. So did we take our views into consideration, or is just a PR complete? They have written whatever they wanted to write and just sent it to the president. You are talking about over 10,000 pages of recipes. When did the president have time to read through all this to come to the conclusion that it was fair and that he should remove the Chief Justice? And then, for those of us who were sitting in the room where the thing happened, we had 24 grounds of misstated misbehavior from authority and about 4 of incompetence. We are being told that they have dealt with authorities work. We have sent a letter written to the Chief Justice informing her that she has been removed. And they are looking at 3 matters. One of them was that he asked for the expansion of the Court of Appeal to about 20. When Mahama took office, one of the first things he did was to put up about 7 people to be appointed to the Supreme Court, citing that she was the one who even spoke about expansion. At the end of the day, he has got all his people sworn in as Supreme Court judges. And the same reason has been used to remove it. Meanwhile, when Professor Ferry wrote his petition to Nana Addo to remove him, based upon this, the Council of State said there was no prima facie case. The president said there was no prima facie case. As lawyers for the defendant, we put all these reports in to show that there was a res judicata. That matter has been completely dealt with.
Okay, I see how passionate you are about this issue. But then the committee has given their recommendation after listening to all the witnesses, which you were allowed to also present your witnesses during the petition, and they say that there's enough grounds to remove the Chief Justice. As her legal counsel, what's the next way forward, especially because you're in the ECOWAS court and you're contesting this, but she has been removed?
And I'm telling you that there are no grounds for a removal, and that whatever they have done is wrong. Even if the Chief Justice travels and she has to be given a per diem, is it for her to determine how much she will get? I have served in government office before. It is the chief director who work and come and give us money and tell you that this is your per diem. And she's giving a per diem. And part of the per diem is given to the person he's traveling with. No auditor has come out to say that he has done anything wrong. Madam, this is a serious matter. Don't trivialize it at all. And we are using this to say that she has caused what? Has she misappropriated any funds?
And indeed, it's a serious matter. It's the first time something of this nature is happening in the Fourth Republic. But I'm just going through the speech that the chairman of the committee actually read today before submitting that report, 10,000 pages to the president. And he states that, indeed, there were 4 lawyers represented in the first petitioner work, as well as 4 lawyers representing the Chief Justice. He goes on to state that there were different individuals who came out to actually talk about it. And he goes on to state, let me quote him, without disclosing the substance of the proceedings, and since in-camera proceeding is not the same as in secret, we can state that in respect of the first petition, we received evidence by Mr. Ofori, the first petitioner, through 13 different witnesses. And we're just hearing from Counsel of the Chief Justice here, saying that the whole process is flawed, going against this, and they are quite upset. Let me bring in Godwin Edudzi-Tamaklo, Director of Legal Affairs for the NDC. We appreciate your time here on Top Story. Based on the chairman's speech today, he says their work has been done individuals have been cross-examined by the committee, and they've come to the conclusion that indeed this is the way forward. But the opposition, the NDC, MPP, as well as the lawyer for the Chief Justice, feels otherwise. Let me get your initial reaction.
My lady, good evening, and good evening to my learned senior, the respected senior group. I've listened to him. By way of opinion, let me say, President John Dramani Mahama has acted within what the Constitution 1993 requires him to do. He has not taken any decision not permitted by the laws of this country. That said, in listening to him, my senior makes the point that the president, if I'm right, has not had the benefit to make a determination whether the recommendation by the committee was fair to warrant her removal. May I say, there is no such constitutional requirement or responsibility on the president under Article 146 to make a determination as to the fairness or otherwise of the recommendations made by the committee. The president cannot, under the circumstances, say that the committee has recommended based on its facts and that he, the president, disagrees with them. The president does not have the benefit of that factual inquiry to disagree or make a determination that it is fair or otherwise.
Lawyer, let me just get your thoughts on this. There were 3 different petitions submitted to the presidency. Only one has actually gone through the process. Why not wait for the other 2 petitions to go through the process, and then we can relieve her of her duties if indeed enough grounds have been found?
You know the classic example I'll give. And my senior, Ayiko, who on Monday I'll learn under his feet, appreciate that where you have specific, and I use this as I said, criminal charges against an accused person, it does not matter. Once on one of the charges, and remember that the 3 petitions, okay, do not have one petitioner. They are separate petitions. So if, in the wisdom of the committee, they concluded the work of one, nothing under law precludes them from submitting their recommendation. It's as good as in a criminal case, an accused person is facing multiple cases of criminality in different courts. One court can conclude a case and say, on this charge case, we are done with it. I proceed to convict you. And then they'll go ahead and convict and sentence. It does not bring an end to the other charges that you are facing in other courts. This thing had happened many times in our jurisprudence. And so, the whole idea that the committee ought to make its recommendation in respect of all 3 petitions before the president can proceed is not supported by law. It is not even supported by practice. In fact, like we say, they are not consolidated. In fact, even when they are consolidated, we give different judgments. And that is well known. I'm really surprised that, with respect, that position can be canvassed.
Okay. Appiagyei, allow me to come in at this point. I'm just wondering what the international implications will be on Ghana, especially because we know the Chief Justice has gone to the ECOWAS court and she's challenging the entire process. She's actually seeking for some $10 million from Ghana because of the whole process, which she terms as flawed. And already we have issued a verdict.
The last time I checked, Ghana is a sovereign state, correct? We have a unique law called the 1992 Constitution. 2, what I do know is that there is no pending injunction against the government of Ghana from proceeding with the petition or the impeachment processes. In the absence of that, there is no further. I'm also aware, now removed Chief Justice wanted the ECOWAS court to sit during the vacation. That, my understanding, is that did not happen. So there is no further whatsoever with the committee from proceeding with its work and recommending her removal, which recommendation His Excellency the President, John Dramani Mahama, has, on that basis, proceeded to remove her.
Now, thank you so much, Appiagyei Tamaklo. He is Director of Legal Affairs for the NDC. Let me bring in currently Tuah-Yeboah, his lead counsel for the Chief Justice, just to get his brief reaction to some of the concerns being raised by Appiagyei. You've heard the counsel raise salient points about the entire process. He's of the opinion that they've gone through the law and the verdict is clear.
He has not made any submission worth considering in respect of the issues that we are raising. I am not aware of any procedure which says that if you are charged with 10 counts, after 2 counts, the court will stop and say, out of me, I found you liable. The rest, I will not do it. I will not go into them anymore. I have not, in my practice of 44 years, come across any such procedure. What you do is that you go through the entire charges and say that out of 10, I find you guilty on 2. That is all. I don't know what he's talking about. I've never said it before. I've never heard it done anywhere. That while the petitions are pending in an indecent age,
allow me to come in at this point. I'm just going through the speech that was delivered by the chair of the committee today when he submitted the petition and the final findings of the committee to the presidency. In the last paragraph, he says, the second petitioner, as well as the Chief Justice, pleaded with the committee that the second petition, which would have been next to be inquired, to be adjourned, and they actually accepted their request. So it is the case that the Chief Justice wasn't willing to hear the other petitions immediately.
Is that your understanding? That is not what happened. They adjourned the case to last week Monday to start with Shining Stars. We asked for an adjournment because we were preparing our written addresses to file. So he said, can you give us 1 week to consider it? Meanwhile, the Shining Stars asked for 3 weeks adjournment. And the committee agreed and adjourned the hearing to 15th of September. He himself said so this morning, that they have adjourned it to 15th September. What is that you talking about? That they have decided that out of things they will deal with, they are finished with one founder level. And so the rest they will hear. They told us they have adjourned it to the 15th of September. So with this year complete, what do they expect us to do? Are they expecting us to come to the committee on the 15th of September or what? What is the head for? I said we have not even signed our written submission. We did it today. They have not even read it. They have not even read it. They said they are finished.
critics argue that these are independent petitions, and so if one has been concluded, the president has to act on the recommendation of that petition. I'm wondering, what's the next line of action for you as legal counsel to the Chief Justice?
What do you think? What do you think should be the next line of action? They have told you that when they do the work, present their report, the president is to act by it. The president says I've acted by it. Now, at the time the committee was meeting, because it was in camera, we couldn't speak. And I'm telling you, this is the opportunity for us to speak. We are telling you what took place was wrong. That is what we are addressing now. So stop asking us, what is the next line? What is the next line? He has written saying that he has removed the person, and we are now inquiring into the grounds that he said he has used. If you want me to learn, let me tell you that these were the 3 grounds they have used, and they do not make any sense. They don't make any sense. You cannot use yourself to remove a whole person.
Thank you so much for your time here on Top Story. Tuah-Yeboah is lead counsel for the Chief Justice. Earlier, I spoke to Godwin Edudzi-Tamaklo, Director of Legal Affairs for the NDC. My name is Faustina Safo. I'm handing the baton over to Newsnight. Evans Mensah.
It's a major developing story, obviously, and we are all over this.